Yeah, thank you very much, Maneti. And for our listeners, we're trying to put our topic in the Queen's language in order for those other native countries who doesn't understand our Ghanaian language can pick something out of it. Our main topic for this morning is about the impact of coronavirus pandemic on immigration appeals. As such, this pandemic being as far as March 2020 enables the court has to come out with something we call a reform towards how the hearings in the court should proceed. But as far as we are aware, let me talk us through what is appeal, what makes something an appeal, or how can you lodge your appeal, and what's the procedure to go as far as what the court has arranged in terms of if you are supposed to attend your court hearing. So whenever we talk about appeal, it entails you've made an application and they've refused you. And bear in mind, we have going to look at not all applications or not all refusers have right of appeal. So basically, if you're doing your application and your application falls on international protection claim, you are entitled to appeal.
Okay.
Also, if your application falls under revocation of refugee status, or humanitarian protection, your appeal, you have right of appeal.
Okay.
And the other one is where is a decision on EU settlement scheme and or regulation 2016, you also have a right of appeal. And lastly, what we always know about is a human rights claim. If you're doing an application on the basis of human rights claim, you are entitled to right of appeal to an extent, because human rights claim can be certified by Home Office. When it's being certified by Home Office, you are not entitled unless you go out of country to do that.
Okay.
So this is what we have to be bear in mind and careful about these things. Okay, let's look at the reason or what brought about these immigration appeals. So when these things, those who are appealed are entitled, when these claims, you make an application under the human rights, under EU, humanitarian protection, refugee, and your application has been refused by Home Office, and they've granted you something we call right of appeal, you have to prepare your grounds in such a way to lodge your appeal.
Okay.
So in this case, the first thing you have to do is, fine, if you receive the refusal decision, first look at it whether you are entitled to right of appeal or not. So this right of appeal, if you are entitled to it, you need to prepare towards that appeal lodging. And before you do that, you have to come out with your grounds of appeal. Grounds of appeal talks about a situation whereby you think the decision of the Home Office is not in accordance with the law. So you will look at it and see that, fine, what the Home Office have refused me on that basis, I can see they've got the law wrong. So on that basis, this is the reason why I'm challenging or I'm lodging my appeal to the court to have a look at it. So in this case, when you lodge your appeal, it's two things. Lodging the appeal is whereby whether you need a paper appeal or you need oral appeal.
Okay.
Paper appeal is a situation whereby you prepare your papers and you send to the court, and the court will give it to a judge. The judge will have a look at it and make a decision out of it. But when we come to oral appeal, what it entails is when you lodge your grounds of appeal, the judge, it will go to court, and the court will have a look at it and send a copy to your opponent. In this case, when we come to the immigration section, our opponent is the Home Office. So the court will send your grounds of appeal to the Home Office and give them another opportunity to say that your opponent, being the appellant, has lodged an appeal and is basing on these grounds that your refusal letter does not address or does not make it in accordance with the law. So as such, have a look at my grounds of appeal. So the Home Office will send it to their legal team, being HOPO, we call it HOPO, Home Office Presenting Officers Unit, those who deal with their legal bits in the Home Office. They also review the appellant's grounds of appeal and have a look at it, whether what the appellant is saying is right or wrong, on the basis that their caseworker, did he or she had it right or not. So as such, when they realize what you, the appellant, are saying makes sense, or to them, you've got the law right, they will review it, and if there is a need for them to dissent their decision, in this case, they wouldn't go further to the court. They will write to the court that we have a look at the appellant's grounds of appeal and realize at least it meets the law. So as such, we no more going to the court. So we have withdrawn the case. So in this case, Home Office have accepted someone who say a defeat. If that's the right, it won't go further to the court again, and they will issue the appropriate decision to the appellant. On the other hand, whereby Home Office realize that, no, we keep standing on where the caseworker make that decision that it doesn't meet the criteria. So as such, your refusal letter. If they go by that way, they'll write back to the court and say, no, we still stand by our decision. So as such, you can go ahead and come out with your directions and the notice of hearing. So they will respond back to the court. When the court hold it up, the court will say, okay, back to the appellant. I can see the Home Office want us to go ahead with the hearing. So as such, looking at your case, we're going to have a look at it, whether we are going to come out with something we call a case management review or not. So that's where they set up something we call directions. The court directions. So this is whereby the court will come out and say, listen, Home Office, prepare your bundles. Appellant, prepare your skeleton argument and your bundles. So in this case, you, the appellant, let's come back, let's pick them one after the other. The appellant and the respondent. When I'm talking about the appellant, it's a term we use for the person who is lodging the appeal. And the respondent is the Home Office. So when we talk about appellant here, the Home Office, the court will give a direction and say, listen, appellant, prepare your skeleton argument and your bundles for our case management. And the same thing they will ask the Home Office, being the respondent, that they also have to pay their bundles. So in this case, they will set a date for a case management review. And the case management review will prepare towards the substantive hearing, being the final hearing. So in this case, they will look at it and see whether they are all prepared for the hearing. Case management review, on the other hand, is a pre-trial hearing. Because they want to make sure that both parties are ready for the substantive hearing. So in this case, your documents, everything in support of your appeal has to be ready, including your witnesses including your representatives, to make sure that everything is ready in order for them to set a timetable for the final hearing.
Okay.
Yeah. So when everything is done and both parties have agreed on that and they've prepared and abide by the directions procedure, the court will come out with a notice of hearing.
Okay.
So notice of hearing, what I want us to chip in here is what has the coronavirus impact changed everything now?
Right.
Because when we look at it, before the coronavirus season, being March 2020, there has been our normal routine, like the ones I've explained, for them to fix, and there is a hearing, and they will go there face to face, meet the judge, discuss or argue, litigate about the refusal, and if the judge is happy about it and realize the appellant is in the right position, they will issue the appellant, they will allow the appellant's appeal. If they realize Home Office is also in the right position, they will dismiss the appellant's appeal. So in this case, this is the normal thing we were going through as an appeal before the coronavirus stepped in.
Right.
Being the March 2020. So let's come out. As such, the president of the First Tier Tribunal came out with a statement regarding the issue of coronavirus.
Right.
As such, they look at the public health situation, that is it feasible for both parties have to come and have face-to-face hearing or not? Because our traditional hearing was on the face-to-face hearing. But because of the coronavirus situation, things have changed in such a way that we can make no longer the face-to-face hearing.
It's true.
On exceptional issue whereby they can do it, but it should be the coronavirus protocols in place before you can do that. So as such, they came in with how they're going to handle this coronavirus alongside a hearing. So what they decide is they developed something we call a hybrid hearing. Hybrid hearing is a situation whereby, because of the coronavirus situation, not all the parties, being the respondent, appellant, can go to court. So on that basis, the court came out and said, okay, we might need one party to be at the court.
At the court, yes.
So in this case, they will come out with a reason, both the respondent and the appellant. Am I the appellant? Appellant will decide, I want to go. Then respondent will say, okay, I'll stay behind. Or respondent will say, I will go. And then the appellant will say, I'll stay behind.
Okay.
So this is whereby the coronavirus changed the procedure or the hearing situation at court.
Okay, that's the face-to-face. No more face-to-face.
Yes.
Okay.
Face-to-face is hiding behind it, but they've reformed it.
Yes.
Yeah, if I may say it that way, they reform it. Because the hybrid one is, on the other hand, is some sort of a face-to-face, but it's limiting people, the number of people at the court.
Okay.
Yeah. And the other one which they introduced and they are using it more often is remote hearing.
Hearing. Okay.
Yeah. Because the remote hearing is a situation whereby all the parties will be at their various places, not to come to court.
Yes.
And they will be doing either video hearing or telephone hearing.
Wow. Interesting.
Yeah. So on that basis, they introduced all this technology in such a way that we can say coronavirus has stay us back. So as such, we won't go to court and wait till coronavirus is over before we start our court hearing.
Okay.
Impossible. They have to develop a way of dealing with appeal situations. And these are the technology they brought into by amending the first year tribunal procedure amendment 2014. So in order for them to make sure that no one is being affected by coronavirus, these are the things they put in measures or in places in such a way that as long as you've got appeal going on, at least it's their duty to make sure that they get your hearing heard in either of the modes of hearing, being hybrid hearing or remote hearing. But they've also amended their procedural rules in such a way that it's not all cases that needs to be heard at court. In such a way, if the case is urgent, they can decide without letting court hearing comes in.
At all. Okay.
That's it. On the other hand, it's also because of the interest of justice. They have to make a decision. They will go ahead and do it.
Make a decision.
Yes, under Rule 4A. That's the new amendment they put in. So as such, we can see that the court procedure, as we know or we used to know, have a little bit of reform. And they've used this from beginning of January 2021 to June 2021. This is the procedure they are going to use for now. Okay. So if the coronavirus is finally lifted in terms of the restrictions, they will come out with what the court wants to do the next 6 months ahead from June to December, and we will see what another new method of hearing coming out.
Okay.